Recently, the Supreme Court invoked its extraordinary power under Article 142 while ordering the release of A.G. Perarivalan. So, let us understand in this episode who is A.G. Perarivalan and how is he related to Rajiv Gandhi's assassination. In 1991, Rajiv Gandhi, the former Prime Minister of India, was assassinated in Tamil Nadu, Shri Perambadu. Rajiv Gandhi entered the Indian politics in the year 1981 and became the Member of Parliament the same year. He earned the landslide win and became India's youngest Prime Minister at the age of 40. He is well known for his works in the areas of technology, software, education, and successfully settling up the militant rule, or you can say the military tensions in Maldives via its military coup d'etat in Maldives, and restored the then President Gayoom's administration in the island nation. So what happened that this most celebrated Prime Minister was cruelly or was ruthlessly assassinated? For this, let's get back to the history of Sri Lanka. Yes, it is said that the entire assassination It is said that the entire assassination was planned by a Sri Lankan militant group LTTE, which we are going to discuss later. So let us start with where did it all begin. In 1948, Sri Lanka, the then named as Ceylon, got its independence from the British regime. At that time, the Sri Lanka was dominated by the Sinhala community, which was a Buddhist community. And there were Indian Tamils present in the nation, which counted for 23% of the population. After the independence, Sinhala community wanted to establish a majoritarian state, and they were threatened for the existence of Indian Tamilians in the nation. During the British regime, the Indian Tamils were forced to moved to Sri Lanka to work in the fields or work in the farms. During the British regime, the Indian Tamils were forced to move to Sri Lanka to work in the fields, and since then the Indian Tamilians, they started to live there. However, in the post-independence of Sri Lanka, the Indian Tamilians were discriminated abruptly. In 1956, the official language was stated as Sinhala in Sri Lanka, and further in 1972, a new constitution was framed in Sri Lanka in which they declared Buddhism as their primary religion, and the country changed its name from Ceylon to Sri Lanka. During the 1972 or during the 1970s, it was finally came up to the Indian Tamilians' mind that the Sri Lankan government is being highly biased regarding their rights and were not involved in any kind of peaceful or humanitarian efforts towards them. Which is why during 70s, several militant organizations were formed in Sri Lanka, and amongst which the LTTE came out as the most powerful and most prominent militant organization in the country. The LTTE, or the Liberation Tigers of Tamil Eelam, was a Tamil militant group fighting for the rights of Sri Lankan Tamils. Again, like I said, it was the most powerful militant group at that time, and it was headed by Velupillai Prabhakaran. During the 80s, the tensions between the militant group LTT and the Sri Lankan armed forces graved. In fact, after the 6th Amendment in the Constitution of Sri Lanka, the situation worsened, which led to the grave incidents like Black July, and even it gave birth to the civil wars in Sri Lanka. During that time, even Indian peacekeeping forces or even Indian government was quite tensed about the ongoing tensions in Sri Lanka. Of course, it is a neighboring country, and we are worried about, even we are and we were worried about the situations in our neighboring countries. Back then, the Indian Armed Forces has undertaken Operation Pumalai. So this Operation Pumalai, as it was codenamed as the Eagle Mission 4, right? So under this, the humanitarian aids were provided to the northern and the eastern parts of the Sri Lanka, where LTTE was sustaining their operations, right? So during between the timeline of 1981 to 1985, 86, even in India we faced several political turmoils. As you know that 1984, our former Prime Minister Indira Gandhi ji was assassinated at that time. So during the time, India was slightly, it paved its way away from, Sri Lanka, and we were in itself struggling for the political arenas, right? However, during 1984, 85, 86, the India started to take interest in the Sri Lankan internal matters, and we decided to deploy the India's to the peacekeeping forces in Sri Lanka's district, where the civil war was quite aggraved, right? So during that time, as you can see here, that in 1987, finally, the former Prime Minister Rajiv Gandhi, he signed the peace accord with the Sri Lankan president, that is J.R. Jayawardene, and basically this peace accord was to reinstate the peace settlements between the militant groups and the Sri Lankan government. And according to this accord, all the militant organizations in Sri Lanka were supposed to surrender them, and in return the Sri Lankan government was delivering them their rights to stay in the country, of course, and even even the devolution of the power was also allowed under this accord. However, LTTE feel betrayed due to this peace accord. They wanted this peace accord to be between them and the Sri Lankan government. But since India did not take stand with LTTE in this peace accord, so this has actually created a kind of drift between India and LTTE, which is why it gave birth to the assassination. So later on, what happened was that earlier the peacekeeping forces were deployed in Sri Lanka to create the peace settlements between the Sri Lankan armed forces and the LTTE, whereas after this accord, the peacekeeping forces in itself, they found themselves in a situation where they started war with the LTTE. And you can imagine a situation when you are actually, coming up to resolve the matter between two of your friends, and later on what happens is that the two friends, they actually come together and now they stood against you. So India was exactly in the same position back then. So in 1990, however, during the VP Singh's, when VP Singh was the Prime Minister, the IPKF was returned back to India. However, during the 1990 Lok Sabha elections, again LTTE was suspicious that there might be chances of Rajiv Gandhi coming back to the government and being the Prime Minister again, which is why they had planned this assassination. And finally, when Rajiv Gandhi, he was on his tour, he was on his rally to the Tamil Nadu, this assassination was rightly planned in Tamil Nadu. So let us understand why this matter was reviewed or recalled, which dates back to 1991. So recently Supreme Court has invoked his extraordinary powers via Article 142 and has released the convicted in this case A.G. Perarivalan. At that time, A.G. Perarivalan was 19 years old, and it is mentioned that he has bought those two 9-volt batteries which was used by the woman named Dhanu, who triggered the suicidal bomb which was tied along her waist. So this 9-volt batteries were bought by AG Perarivalan, and it was handed over to Sirivasan, who is said to be the mastermind of this assassination. Now let us get to the timeline of this event. So in 1998, a lower court has convicted AG Perarivalan amongst 25 others under the Terrorist and Disruptive Activities Prevention Act, and they were sentenced to the death. Then further, in 1999, even the higher courts have also upheld the decision and sentenced them for the death penalty, right? However, in 2014, the Supreme Court has reduced the death penalty to the life imprisonment on account of their mercy petitions. Then further, in 2015, he filed the mercy petition under Article 161 with the Governor of the state of Tamil Nadu. Article 161 provides Governor the power to grant the pardons, reprieves, respite or remissions of the punishment, or to suspend, remit or commute the sentence of any person who is convicted of any offence against any law relating to the matter to which the executive power of the state extends. So then further, when this matter came to the Tamil Nadu government, so he submitted his mercy petition to the Tamil Nadu state seeking the release under the Article 161. At that time, the cabinet of Tamil Nadu was headed by the Chief Minister Edappadi K. Palaniswamy, who recommended, of course, his cabinet recommended the release of all 7 convicts, including the Perarivalan. However, the governor upheld this decision, or governor upheld this petition and has kept it in it itself without ongoing with the pardoning. Due to this cabinet saying yes to the release, it had actually created a stiff with the center government, who argued that with this release there might be some international ramifications of the decision. However, center also stated that this decision should be taken by the governor. The governor has kept this decision pending for over 3 to 4 years, due to which many a times in 2020 and 2021, the Madras High Court and the Supreme Court too has warned the governor for the inordinate delay, which is a compromising state as per the fundamental rights. So then finally in 2021, this file was moved to the President's office, but again it was delayed due to some reason or the other, and then finally Supreme Court took the call and decided on this matter while exercising the Article 142. So let us understand what is this Article 142 we are discussing over and over. So firstly, let's understand that Tamil Nadu's cabinet was actually agreeing to release these convicts, but due to the delay in the governor's ordinance, it had been subdued for over 4 to 5 years. So finally, Supreme Court has come up to the matter and has decided to take a call under the Article 142. So the court has also dismissed while giving the ruling that the center's argument that the president exclusively and not the governor had the power to pardon any of the convict in any of the case which is under section 302 of IPC, saying that this contention would definitely render the Article 161. So indirectly Supreme Court has said that center government's argument of exclusively saying that only president can pardon a murder case, or president can pardon a convict under Article 302 of any murder case was inappropriate, as the governor under Article 161 also holds the right for the same. So if this thing would have been avoided by the Supreme Court, then the 70 years of the governors pardoning the murderers, giving them the pardons in the last 70 years would have held invalid, which is why the Supreme Court has held this argument as totally dismal, right? So of course we are talking about Article 142. So this article, it provides a discretionary power to the Supreme Court, as it states that the Supreme Court in the exercise of its jurisdiction may pass such decree, or they may make such order which is necessary for doing the complete justice in any cause or matter which is pending before it. So even for example, the cleansing of Taj Mahal or any kind of justice which is pending in front of the Supreme Court has shown the result of total justice only with this Article 142. Even during the evolution of this article, many lawyers and even citizens, they lauded the Supreme Court for bringing justice to the most deprived sections of our India also. Even during the Bhopal tragedy case, when the Union Carbide Corporation, the Supreme Court itself placed it above the laws of Parliament or any state legislature, and stated that it may pass any judgment to bring complete justice, and in itself it can pass any judgment which can go against any law if it is for making a complete justice to the citizens, right? However, in the Supreme Court Bar Association case, however, Supreme Court has held during that time that the Article 142 is not to supplant any law, rather it is to supplement the laws. So over the period of times, we have seen that Supreme Court has actually entered or given the judgment in the areas where it was forbidden due to the doctrine of separation of powers. So the one such case, as we can see right now, is the ban on alcohol. So as you must know that recently the center government has also passed the law that there has to be a ban on the sale of liquor in the national highways. However, the Supreme Court has put in a place in this matter, and they had put a ban on a distance of the 500 meters by invoking the act of by invoking the act, or by invoking this Article 142. So we have seen it several times that Supreme Court has tried to make its stance over the laws of Parliament or the state legislatures wherever they find it fit, that whenever a person or a convicted person is being evaded from its fundamental right or from its right of complete judicial redressal, which is actually the case of A.G. Perarivalan, the Supreme Court at that time will enter the arena and will pass any judgment. So this has set as a benchmark judgment for the other 6 convicts now, and Tamil Nadu government may, on the basis of this judgment, may even proceed further for the release of the 6 other convicts which are still in jail, or they have been given the life imprisonment in this case. So it is now up to you to decide that who is wrong or who is right. Technically, if we talk about the Indian laws are the supreme power in hands of people, and the judicial redressal is our fundamental right. So this is Nitika signing off from this topic, and I hope you like this video. If you did like it, please share it with your friends. Thank you so much, everyone.